Joining us now, Saugata Roy, former UPA Minister of the Trinamool Congress. He joins us from Kolkata, and Meenakshi Lekhi, a leader of the Bharatiya Janata Party. Thank you both. Mr. Roy, hearing this, what are your first thoughts of this new judgment?
So this judgment is a good judgment in the sense that it's an attempt to cleanse the electoral system. But whether this judgment is good law, I am not sure, because it totally cuts out section 8(4) of the Representation of People's Act, which has been in the statute books for a long time. The Supreme Court has opined that Parliament had no business to add this amendment. But if you consider natural justice, then a person is convicted in a lower court, then he has a right to go to a higher court. Now that is part of the justice system. Now if you say once a lower court convicts you, you are permanently convicted and you will be out of assembly or parliament, I do not think that it will be entirely judicious and fair.
Actually, sir, this is not even just, sir, this doesn't even talk about conviction. It just says if you're in jail, then you can't contest. It doesn't care whether you're convicted, you're only being detained. It just says if you're in jail, you can't.
No, it doesn't say that. No,
sir, this is a new
Shunetra,
one.
you're going wrong there. Because the basic, no, I have seen the new one. The basic law is that if you're convicted for 2 years, you are barred from contesting for assembly and parliament. The other thing is that if the conviction takes place, earlier what happened, people were convicted in a lower court, while they are MPs or MLAs, they appealed to a higher court and their membership stayed. Right. Now this judgment says that their membership will go, and if that person is again released or acquitted by the higher court, he will retain his membership, which will have no meaning in case the term comes to an end.
Yes.
So there is a matter which is to be looked into. While this is an honourable effort,
yes, no, I
to
understand,
cleanse the political system of
confusion.
criminal elements, it is not necessarily good in law.
I know, but sir, I think you're talking about the judgment which we have debated, which came yesterday about the conviction, and if you've been convicted even before your appeal, you are. Meenakshi Lekhi, the details which Arunachalam Vaidyanathan, NDTV's Supreme Court correspondent, is reporting, the new judgment which has come, which equates being in jail of having the right to vote with having the right to contest. Do you think it's sound? Are you will the BJP welcome it?
You see, BJP has not met, and we have an internal consultation mechanism where we take party stands and party policy. But I am here right now representing not the BJP, though I am a BJP worker, but I am representing legal fraternity and I'm a lawyer. Now, being a lawyer, how I read things and how I read enactments and how I know the history and political history of this country is what I would like to put across you. And so far as the our position as a political position is concerned, we will get back to you on that.
Okay.
Now, 62(5), if I read, no person shall vote at any election if he is confined in a prison, whether under a sentence of imprisonment or transportation or otherwise, or is in lawful custody of the police.
Yes.
Now, if one understands it right, what the court seem to have done, though I have yet to go read the entire judgment in totality, right to vote has been equated to right to contest elections, right, which according to me is a failing, for the simple reason, for right to contest from a particular constituency, that you have to be on the electoral rolls. And when a person is on electoral rolls, the two cannot be equated, because one person has to be on electoral rolls, not necessarily participate in the electoral process in terms of voting. And in terms of voting, a person, and I'm coming back to the history, my own father-in-law contested election from jail while he was put behind bars in emergency. George Fernandez was another person who contested elections from jail because they were falsely implicated in cases and they were put behind bars, and they were honest, honorable people who were fighting the political system.
Right.
Now, if we replicate that in today's time and tenure, we have a person, say for example, Mrs. Gandhi's constituency, Rai Bareli. Hardly anybody contests against her. Dimple Yadav, nobody is allowed to even file nomination. Now, this will be a tool in the hands of people who want to misuse it by not letting people even file nomination. Once you have dared to file nomination on false pretexts, which may finally be allowed to go on bail or allowed to go on whichever format, will be allowed to go, and then you have disqualified them from contesting election.
Yes.
And this you need to see in terms of another judgment by the Supreme Court in recent past, where Italian Marines were allowed to go back to their country during December vacation so that they could participate in the voting process.